Hey everyone, welcome to another edition of Bitcoin Law Review with your host, Tone Base. We got another great panel of lawyers and we have some really good topics coming up. I'm really hoping my audio is much better this time. I'm still broadcasting from the same apartment here in Barcelona. So I will try to keep an eye on the live chat in the beginning to see how the audio issues are. So without further ado, let's introduce our panel and we will get right into lots of SEC related topics that have taken place over the last 2 weeks. Let's start with Drew. You haven't been on the show in a little while, Drew. Give us a little update and just refresh our viewers of what kind of lawyer you are and where you work.
Thanks, Tone. Nice to be back. My name's Drew Hinkes. I'm a lawyer. I'm in-house counsel for a company called Athena Blockchain. We, through a FINRA licensed broker-dealer, provide investment banking services for issuers of securities in tokenized form. I also teach at NYU Law School a class called Digital Currencies, Blockchains, and the Future of the Financial Services Industry. Great to be back, and thanks, everybody.
Cool. Thanks, man. I guess, Sasha, let's go with you. Where are you these days? You're back in the US, Miami or DC? Where are you?
I'm in Tampa this week. Well, St. Pete right now, but close enough. Yeah. Yep. Still chugging along with DLT Law Group. Working on working on one case with Mr. Restless right now. So that's kind of been fun the past couple weeks.
All right, cool. Thank you for that. Jason, I see you you moved to your new place, but still need a little furniture there. The guitar's still around.
Listen, all of this area behind me is left for creative space, man. You know, that's all there is to it. Listen, I'm Jason. I'm a lawyer. It's hoodie day. I found out. I didn't get the memo, but I ran to the closet. I've got my Willamette Law hoodie. Right, you can take your NYU, Drew, and you can put it where the nonce is. You know what I'm saying? It's all. Listen,
I'm gonna concatenate it to the end of your string, buddy.
Bearcats. That's all I'm saying.
That's where I put your nuts.
Bearcats.
Hash this, buddy.
All right, Battle of the Lawyers.
The worst jokes ever.
Hey, unless you guys are on a cruise with only a bathing suit, it doesn't count. All right, last but not least, Bill, how you doing, man?
You know, I'm fine, Tone. Bill Restless here in San Diego, Restless Law Firm. I tend to practice in the intersection of the blockchain and securities law. I'm one of the lead plaintiffs' counsel on the Tezos class action and some others. And I'm a little under the weather today. I know it was last time I was too, so I'm at home in my hoodie. And as I said, Jason was nice enough to put his hoodie on so we could all commiserate together. But again, don't expect too much from me today. There's a big asterisk in everything that comes out of my mouth.
Yeah, I didn't know it was possible to get sick in San Diego. It's like the nicest, most consistent weather in the world. All right, guys, let's jump into our stories. We got a lot to cover. We missed the show last week because of connectivity issues. So let's give it another run. So here's our first story. I found this particularly interesting. The SEC suspends trading in Bitcoin and Ethereum related products over an ETF confusion. So this is something that I've been talking about on our financial show quite a bit. And look, the financial laws are confusing, which is why with all these companies trying to create an ETF like the Legality and all these other ones, an ETF has a very specific definition. The GLD ETF, for example, is physically backed by gold. The SLV ETF is physically backed by silver. An ETF actually has to be backed. Your product doesn't have to be an ETF. Your product could be an ETP, an exchange traded product, instead of an exchange traded fund like an ETF. There's also an ETN, an exchange traded note. Now, I was never a professional. I was just a risk analyst. I was just a guy building risk models and a trader from home. And I know this, right? This is the crazy part. I'm aware of this, right? An ETN is just, you try to represent the price of an underlying asset with like swap contracts, okay? Between counterparties that have enough liquidity not to go bankrupt. So it's all paper backed. So the SEC, of course, a year late or 6 months late, suspended the 2 Swedish exchange traded notes because they were ETNs, but they were apparently listing them as ETFs in some of their paperwork. So they basically didn't have the right paperwork. So those products got suspended. And here's the order itself, right? So the SEC suspended the 2 products because they were ETNs. I knew they were ETNs. I read some paperwork, they said that they were ETNs, but apparently in other paperwork, they were listing them as ETFs, which implied that they were going to be actually physically backed by Bitcoin and Ethereum, but they weren't physically backed by Bitcoin and Ethereum. So the SEC has suspended them for, looks like 11 days, and we'll see what happens next. Here's crazy. If you actually held these products, guess what? You can't trade them right now. And I guess this is the difference between having the ability to trade a physical asset like Bitcoin or Ethereum and trading it as an exchange traded product or note or ETF, where a regulatory body can simply suspend that trading. Any general thoughts? I guess there isn't really much debate over this. I don't really know how this stuff works from a legal perspective. I don't know if they're going to get a fine. Are they going to get a slap on the wrist? But I think the biggest takeaway here is that the SEC has global reach. Global reach. This was an exchange traded note trading on the Swedish exchange up in the Nordic, or I think they have like a joint Nordic exchange. Though I had the ability to trade this sucker from my account because I have an international broker as a US citizen. But this shows how far the reach is of the SEC, that they can just tell the Nordic exchange what funds they can and can't trade with. Anybody want to jump in first? I guess, Drew, let's go with you.
Sure. So to me, this is a relatively minor thing. Because it has crypto associated with it, it becomes headline news. For whatever reason, the public just gobbles up crypto news and can't get enough of it. I guess in the old days, you would say it sells papers. But what you've got here is a product that was okayed by the SEC, that was being traded apparently on, traded on OTC Link, right? And what you got here is a completely, from everything I can tell, acceptable product. The issue is that there was conflicting information in the market about it. I'm looking at a different order of suspension of trading. I sent you a link if you can put it up. And what it says in this one is that the broker-dealer application materials submitted to allow the offer in the US called them exchange-traded funds. Other public sources called the instruments exchange-traded notes. The issuer calls them in the issuer's offering materials non-equity linked certificates. And then you've got the instruments themselves that are on the NASDAQ, OMX, and Stockholm's and are quoted on the OTC link. So what the SEC is saying here is, look, if you, depending on where you go, you get 3 or 4 different explanations of what this thing is you're buying. And one of the things that the SEC wants to do is make sure people understand what it is that they're buying. So this strikes me as the sort of thing that can be cleaned up relatively quickly. It doesn't change the quality or the character of the instrument that's being sold or offered here. I think that the ETN is sort of an interesting approach to getting a product that's based on an underlying asset to market. And I think that what we have seen done here, which is an asset available on a European exchange that finds a way to then get available on an American stock exchange, is going to see a model that we see used a lot in the future. And so the question becomes, do we see this sort of mistake made multiple times, or is this going to be the learning lesson that others look at? I think the takeaway is if you've got a product that's being marketed in a jurisdiction, say Sweden, and then you want to bring it to the US, you have to make sure that your lawyers in these two jurisdictions talk to each other and they understand what the nomenclature is that makes sense in that jurisdiction.
Anybody else want to jump in on this one?
When I was looking at it earlier, it looks like the main rule that they've violated or that is, being looked into here is 15C211, and that is, it was created to prevent fraudulent or deceptive or manipulative acts among broker dealers publishing securities quotes. Then I looked at what you have to do to comply with that law, and it's pretty intense. You have to, for anyone to do any kind of quotes, like to quote a Reg A or OTC stock, the broker dealer has to have a prospectus that's been filed within the last 90 days. They need a copy of the offering circular that's less than 40 days old. They need a filing report with the SEC on the Form K and the 10Q reports. And they also need the name of the issuer, the address of the principals and the CEO, all their executive officers. They need their full names, addresses, the state that the company is incorporated in, the name and address of the transfer agent, of the issuer's business, and any recent financial information on the issuer for the last 2 years. So I think in these crypto companies, for any of them, we don't have that kind of information generally disclosed. So it's a big leap to be requiring this stuff. And then the broker dealer needs to have a reasonable basis for believing them, believing the information. And they need to keep a record for, I think it was 5 years, of the circumstances surrounding the quote. But there is one exception if they're quoting someone that's actually a U.S. national securities exchange, then they don't need all that. So it just makes it basically any of these crypto things could be considered OTCs, and if they're going to look at them all as securities, and then it would mean that to quote them, you need to go through that whole process unless our exchanges start becoming national securities exchanges. So it's kind of a lot of regulation.
Well, hang on, Sasha. One thing about these ETNs is that they had gone through a process of getting listed in their foreign jurisdiction and ostensibly complying with everything that was necessary to get them listed on an OTC, regular old securities exchange in the US. I think the issue is that there were some patent ambiguities between what they said in certain documents and what some of the marketing materials looked like. And so I don't know whether, based on the fact that they're registered in on an exchange in Europe, meaning a real securities exchange in Europe, and then they come and they get registered on a securities exchange in the US, whether they have to do everything under 15 C211, or whether this is sort of the kind of thing that would apply to crypto companies generally. This was a product that was already being offered in Europe for a while, in compliance with whatever I think Sweden is the home jurisdiction, in accordance with their law.
So, this is Jason. At the end of the day, this is what I would call kind of a big nothing burger.
Yep.
There was some confusion. There was some cross promotional materials that didn't match. And, under the SEC's authority, under 12K, they can suspend trading for just about anybody, anytime, if there's even an inkling that there may be some materials, right? Bill, you talk about this a lot. The purpose of the SEC is to make sure that there's adequate disclosure for investors, period. So under that analysis, if there's some confusion in the disclosure documents, clean up the confusion, make sure that the investors have the right information, and move on. This is, it's a nothing burger.
Totally. And I just checked. The Bitcoin Tracker one has been trading on the NASDAQ Stockholm Exchange since 2015, and Ether Tracker one since October 17. So these were, these were
long established stuff. This is,
stately products by crypto standards.
All right.
Legacy investments. Legacy. Yeah.
Yeah, no. So thanks for that. Hey, Sasha, any chance you can turn up the volume on your side on your microphone? It's coming a little too low. So see if you can do that for the next topic. All right, guys. Actually, we're going to stick with just a general observation of the SEC. It's not really a topic as we transition to the next story, which happens to be SEC related as well. But more and more people are starting to pick up the fact that in the very famous William Hinman presentation, of him stating that Ethereum, let me find it here. The statements here where it says that applying the disclosure regime for securities information, where he states that Ethereum network is a decentralized structure, but he specifically stated that it was based on my understanding of the present state of Ethereum. So this was mostly an opinion. We have had a few articles just coming out that are trying to highlight this, that the SEC has not made any official statements that cryptos are or aren't securities. And we continue to explain to the people watching this show and that watch my normal show that it's pretty much established in the law that Bitcoin is not a security. But other than Bitcoin not being a security, everything does not have a definitive answer of it is or isn't, including Ethereum. So I just want to get Jason's comment on this. Jason, because you were a bit instrumental in making sure that Bitcoin is not a security according to the law. And as far as you know, nothing else has a similar, definitive statement on whether it is or isn't. So just maybe take like 2 or 3 minutes and just remind us of that slight back history and how you see it.
Listen, I don't need 2 or 3 minutes to do that. What I can do and what I talked with Sasha about in basic securities law cases. This is my binder of basic securities law. And one of the first cases that I like to examine is State v. Whiteacre. And one of the things that it says in there very specifically is admissions by a party or by counsel on the record are taken as affirmative admissions and built into the record. So when the SEC said that Bitcoin is Bitcoin was not a security in the SEC v. Shavers case, that's it. That's an admission. So whether there's an argument now that since 2014, maybe Bitcoin has become a security based on some continuum of analysis that maybe it's no longer as decentralized as it was then, and there's some indicia of centralization that would take it outside of that realm. I don't think anybody's arguing that. But at the same time, I think there's a distinction. If you can put that Hinman letter back up again, please.
Sure.
And that area that you highlighted. So the distinction there, and I want to make sure we look at this, is based on my understanding at the present state of Ether, right? And Ether is the instrument, right? Ether is the instrument, and that's the key designation there. The thing that's being actively traded is Ether. It's not talking about ERC20 tokens. It's not talking about the sub-assets that are created on the Ethereum network, et cetera. The actual thing, Ether, which gets traded on exchanges, and I'm sure some of you have received Ether for payments for services. I know I have. That itself is not a security because the Ethereum network and its decentralized structure, current offers of sales of Ethers are not securities transactions because in my estimation, they have transmogrified from the original potential investment into what is now basically just a currency, right? And that's how I read the Hinman letter is how is your asset, whatever that asset is, being used? Is it being used as an investment or is it being used as a currency? And I think that's just kind of an oversimplified way to go through the 13 different point items that Hinman lays out, which Hinman is basically a combination of Howie, Sobieski, and Glenn Turner, right? So Sobieski being the risk capital test.
So this, there's a lot of pronouncements out there about whether something is or is not a security. And what we have is, for this Hinman letter, is the opinion of one commissioner of the SEC. And as Jason said, that's really not binding on anybody. It's not binding on the SEC. It's not binding on courts. There could be the situation that Jason was talking about when there's an official, as you said, admission on the record, what's called a judicial admission, and that could establish against the SEC itself that the SEC cannot go back and say that it is not a security, or excuse me, is a security after it's already said that it's not a security. It can't, the SEC against itself can't contradict itself. That determination may or may not be binding on courts. And what we don't have yet is any courts that have definitively ruled that a specific fact pattern constitutes an offer or sale of securities. And we're going to talk about that more today, but really there's two ways that this official pronouncement could happen. One, either you get a federal district court saying that a particular fact pattern is a securities offering, or you get the SEC in response to notice and comment rulemaking say that a specific fact pattern is constitutes a securities offering. We don't have any of those yet.
When's the last time, Bill, and Drew, I'm going to ask you this for those that are listening. This is Jason. You can't tell because Tone still has his screen share up while he's playing on his cell phone. But I want to ask you the question, Bill, Drew, even Sasha, when's the last time the SEC actually went through a notice and comment rulemaking process in order to modify their regulations and their enforcement process?
No, I know Reg D gets.
I don't know one
updated.
Well, sure, Reg D, Reg A plus, right? But things that they enforce, right? That's all registration stuff. I'm talking about enforcement, the enforcement side.
Yeah, so I'm going to make my comment short and sweet. The SEC does not tell us generally that a specific product is or is not a security. People expecting the SEC to wake up one day and start issuing memos saying these 19 are not securities, but these 26 are living in a dream world.
That's right.
The law is set up so that you register your security or you pay a penalty for not complying. How do they get you to pay the penalty for not complying? They bring an action against you, either in administrative court or, if they think it's severe enough, in district court. And they ask a judge or a jury to make a finding that you offered something that under the law was a security. The onus is on you as the issuer to comply with the law. And that's why people hire lawyers. They find people who are really experienced who can give them advice as to how to navigate all these laws. Now, there is the notice and comment that Jason mentioned, which you might see somebody come out with something with a ruling as to a specific asset. Mr. Hinman's speech was super interesting and gave us all a lot to think about. It was the comments of one very highly placed individual at the SEC. It is not binding law, although I have heard of very good law firms that have completely pivoted in their legal advice based on it, which to me seemed interesting. And people who sit there and market their offerings as being SEC compliant or approved by the SEC because they filed a Form D and they're following the law may have another thing coming to them, because that may or may not be a misleading statement on its own by itself. You may see people going to the SEC and asking for what's called a no action letter, which is a statement from the regulator saying, based on the facts you've provided me, we would not prosecute you for this or seek to take an action against you for this. And that's a way that somebody could get functionally a statement from the SEC that it's not a security. But if you're waiting for the SEC to give you a list of things that are and aren't securities, until yesterday, I would have told you you're dreaming. But yesterday, something weird happened.
Yeah, right.
Yesterday, the SEC announced a consent agreement with Token Lot. And Token Lot was acting as a broker dealer. And Tone, don't kill me, I'm jumping around here. But
no, this is perfect. You're transitioning us into the next step. So this is great.
I may have a face made for radio, but I can talk the talk, my man. So the token law thing was really interesting because it's the first action against somebody for doing broker-dealer things without having a broker-dealer. And one of the things that was mentioned here, which is fascinating, is it actually says in here, if you scroll a little further down, or actually it's in the second paragraph, it reads, Michigan-based token lot received orders from more than 6,100 retail investors and handled more than 200 different digital tokens, which the SEC found included securities. I would love to see the list that they used internally when looking through those more than 200 tokens and to see how they found that they include securities. Now, it could be that token lot was hosting and allowing for secondary trading in things that were obviously issued as Reg D and Reg S securities, which means that they were issued pursuant to the exemptions from registration. If it's that simple, it's that simple. But if there's some list out there that the SEC is maintaining as to tokens that may have been issued prior to the Dow report when everybody was put on actual notice, that would be interesting to me. There's a lot of weird things about this opinion or this press release that we can get into, but going back to the core question, don't rely on the SEC to give you a categorical list of what is and is not a security. Look at how it's offered, and if you're not sure, call a lawyer.
All right, we're gonna go ahead and stick with this story because we are moving on. But again, I continue to try and drive the point home that Bitcoin is definitively not a security, and everything else we don't know. Is that a fair assumption?
No, I'm not going to agree with that. For those watching, this is Jason. The only reason I'm not going to agree with that is that despite the judicial admission, there are certain factors that may apply to Bitcoin either today or in the future, where the SEC could come back and say that Bitcoin is a security. So I don't want to say definitively that Bitcoin is not, because there is no restriction on new facts and new information coming to light or new circumstances that would take that out of that realm. Now, I'm not saying that just to be contrarian or to be a fear monger. I just,
Okay, no, that's fine.
You know what I mean?
Well, hang on. I think we can all say, Jason, work with me on this. When issued, when it was released into the market, Bitcoin was probably not a security.
Oh, so interesting. So back in 2013, 2014, when I first started looking at this, some of you may know I used to work a lot with state and federal regulators, and at Willamette Law, Tone, let's go back to, the individual shots instead of the screen share. Willamette Law.
All right. You gotta.
You're gonna put up your gear. I'm gonna
Willamette Law. Yeah, no.
Oh boy.
Hey, get that out of there. Get that. Willamette, Bearcats, go. So
you gotta show university, man. I got no problem with that. I got my Florida State gear, but they lost the first game, so I no longer have to.
Yeah, that was terrible. That backpack thing is embarrassing, Tone.
So bad.
Dude, no, it's great. It's great. I'm so busy, and they lost the first game. I don't have to watch any more college football the entire season. It's totally irrelevant now.
Yeah. So getting back on point, I had the distinct honor and pleasure to study under Mike Eisenberg. He taught the same course that he teaches at Columbia on securities regulations. He taught it at Willamette. He became a good mentor and friend, ended up getting the placement at the Oregon Division of Finance and Corporate Securities, where I was able to learn more and more and more. And over the years, Mike and I have done a lot of things, including filing, sua sponte amicus briefs on issues together. And when I was first looking into Bitcoin, Mike and I talked about it extensively. And for those that don't know, Mike Eisenberg was a former in-house general counsel for the SEC and was considered a giant in the SEC for decades. And Mike very specifically said to me that under his interpretation, that the SEC absolutely would think that Bitcoin is a security, but for the fact
Where's
that,
the third party, though?
Let me finish. Let me finish.
Sorry.
But for the fact that nobody knows who Satoshi Nakamoto is. Had that person been identified, had somebody known who that was, if that person could be identified, then upon that release at that point in time, there absolutely would have been a violation of securities laws. And I think since then, a lot of people say, well, if Bitcoin isn't a security, why am I? And the response that I give is, people know who you are. right?
Well,
People know who you are. And
so I
that's the
agree.
difference. Yeah.
So Jason, I agree with you in one context. If you had an identifiable issuer, they would look at the mining. They could hypothetically look at the mining process and say, this is just clicking buttons and buying special computers instead of directly sending value. So we can look at that as consideration, and you get the thing which has some value. I could see the argument. I think the reality is that the majority of folks do not consider Bitcoin to be a security. However, there's only going to ever be one time in which we'll all be sure. When somebody sues somebody, the issue is briefed, evidence is provided, a court rules, somebody takes an appeal, and an appellate court rules. Then we'll know.
All right, Jason, so one more then. Okay, so I understand your point, but you do agree that for the moment, Bitcoin is in the legal record is not a security, even though there's a possibility it can change.
Yeah, I think that's right.
Okay, but nothing else in the crypto space has the same kind of current assurance that it's not a security.
Well, I can only speak for the United States.
Right, in the US.
That would be my interpretation,
Okay.
yeah.
So in order, okay, so in that case, let's see if you can agree with this. In order for the SEC to change the fact that Bitcoin, they believe is now a security, it would have to go through the legal system to get that done, while in order to declare anything else a security, they can just say it.
No, that's not right. I think
That's not right.
they could do it through an administrative or legislative process. It could absolutely be changed.
Okay.
Also, the CFTC has sort of grabbed Bitcoin and said, we are electing to exercise jurisdiction over this. The
That's right.
CFTC has a different statutory framework. The Commodities Exchange Act, everybody calls it the CEA, actually has an express definition of what falls under its jurisdiction. It's got all kinds of weird stuff in there. It's got weird carve-outs, like agricultural products are in, but onions are out. Movie ticket receipts are in, but other things that don't make sense are out. The CFTC grabbing it and saying affirmatively that they're exercising jurisdiction over it is a strong argument to suggest that it's a commodity, not a security.
Actually,
can I point out too, Mr. Hinman in his speech came right out and said that he doesn't believe Bitcoin to be a security.
right. So if we go all the way back to SEC v. Shavers, I argued to Judge Mazant that the reason we didn't need these transactions that Shavers was dealing in was that Bitcoin was more a commodity and this should be regulated by the CFTC, and that these transactions should be regulated by the CFTC and not the SEC based on the form, function, and way that they're created, and the reality of what Bitcoin is as a commodity. But at that point in time, CFTC hadn't come out yet and said that. So, you know, but I think from that case, you really have to look at the technology, right? When you're looking at mined coins, not issued tokens, right? Those are two different things. Issued tokens are not, I think, in any sense of the term, can even be considered to be a commodity. What do you think, Drew?
I think that's probably right. They might, an issue token could be something like a payment instrument. It could be a discount card, a loyalty, indicia of a loyalty club membership, prepayment instrument. But if
I think the thing that makes Bitcoin a commodity fall under that is the mining process, right?
Yeah, but like you just said, you could make a plain-faced argument, especially since we go substance over form, that mining, which requires you to buy some computers and spend some money on electricity, is just an indirect way of directly providing consideration to the person that operates the network, if there's a person that operates the network.
But that's a nuanced separation in a different transaction, right? So the mining contract itself, the act of doing that would be the investment contract, whereas the promise of payout is a portion of the commodity that's being issued. The end result product of the mining, I don't think, is the security. It's the act of mining for the future promise of payment in that commodity. That's the investment contract. Two different things, right?
Right. Just like the fact that you own the property in Howie was separate and apart from the agreement to harvest the oranges and sell it all together.
That's right. That's right. Yeah. So it's important when we're studying these things to to keep it
Right.
clear what's being discussed. Right?
Understood that there could be more than one discrete transaction that as a whole is part of the transaction that causes the issuance.
David's here.
Yes, David's here. Hey, David.
David is driving and driving and podcasting.
Let's see if your mic's working.
The technology is working.
Yep, we can hear you barely, but we can hear you. All right, so let's move on with that story. But actually, I just got an interesting question come through. Someone just asked, can someone sue Vitalik Buterin, founder of Ethereum, for issuing crypto without stating that it was a security, then get those rulings that would give us a definitive answer?
Who you want me to take that? Or you want Jason to take that?
If you can make it
I
quick,
want David to take that because he's the guy that would bring that lawsuit. Either David or Bill, right?
That's
I might
right.
defend against that suit, but these guys would do that.
David, you are probably foaming at the mouth for Ethereum to go down low enough so you can get enough Ethereum loser bag holders to try and sue Vitalik Buterin.
No, because the losers have to lose too much. And a lot of my lawsuits right now, I depend on Ethereum trading at close to $500 so that I can buy a new house that makes my wife happy. I personally want Ethereum to go back up.
So what David is saying is that he's specifically conflicted out of the lawsuit because he has a personal value.
And I think there's probably. Go ahead, David.
Whoa, David, I think you're on mute.
Someone asked me recently about the parity hack.
Yep.
And about you suing Vitalik because they lost money in the parity hack, and the fact that after parity, they refused to fork the chain again. Because after the DAO, they forked, after parity, they didn't. And suing the foundation for that. And my response is, and this is my response always on these lawsuits, Sasha just brought up, what Hinman said. I do think in 2019 or 2020 that they're going to announce that the initial fundraising was the sale of a security, and Vitalik is already doing a deferred prosecution agreement, and there will be a lot of good lawsuits that jump up from that. But as of today, as we sit here, look, there's just not a good lawsuit to file today because everyone that actually invested in the Ethereum, in the initial, they're sitting on too much of gains.
Yep.
So I think we have to look at what we want the future to be, not what the past was.
So remember, most people were buying Ether for like cents.
Hey guys, David, you got
Is loud.
yeah. So I will mute David. So when David speaks, oh, maybe it's not coming from David. When David's speaking, I'm gonna have to mute him, and then he'll have to unmute to speak again. I think all the reverb is coming from his cell phone in the car, no headphones. Sorry about that, guys.
So, Tom, my understanding of that question would be like, yeah, you could sue Vitalik for the ICO, but no one has losses from that. But then anyone that has losses on Ethereum, like say they bought it last January, who can they sue? Well, the SEC has come out and said it's pretty decentralized now, so there's no one person. That would be if someone could link Vitalik to the secondary market lawsuits, which I don't think is possible. That's that's the challenge, I guess.
Well, Sasha, hold on. This is where we bring in Bill, because right now, Bill is one of the plaintiff's lawyers in the Tezos lawsuit, and there's not a single person that bought Tezos at that point that can claim that their Tezos is worth less than what the value of Bitcoin is today. So there's no losses in Tezos, yet there's still a complaint for rescission on that contract. So I think there are still lawsuits that are brought. Bill has one of them to where there's no loss, there's no harm, there's no allegation of fraud. There's just give us our money.
What was that, Drew?
Yeah, it's for non-compliance with the obligations of issuance. You can get rescission, but really, I think Tone's question is, can we all make a bunch of money because the price of ETH went down? And the answer is, for the people that bought ETH at 20 cents, they are still way, way up. And you're going to have to see a lot of pain and suffering until those people are net losers. Well, Tone was a more nuanced one.
Yeah, Drew, the other problem is there's not going to be much money to be made. I mean, if Ethereum, implodes and goes to zero, I mean, Vitalik may have some money, but nowhere near the kind of money you think.
So, Tone, I've got to go in about 2 minutes, so I just want to make this one last point. Your question was whether somebody could try to sue the Ethereum Foundation or Vitalik for refusing to fork to rescue somebody from being damaged in the parity hack.
No,
right?
that wasn't his question.
That wasn't the question,
David
but that is a
intervened
better-
and presented that hypothetical. So
Right, but that is a better question. That wasn't the question, but that's a better question if you want to keep going with that one.
Yeah, so my thoughts are as follows. The direct cause of the harm is somebody who accidentally blew away a library that resulted in the funds not being able to be moved out of the wallets. So there's a very attenuated argument to put Vitalik or the foundation as being responsible for what caused the harm. However, you're suing them.
guys, this is Paul's graph. This is the
Right,
Paul's
so-
graph case. It's trains, it's fireworks, it's awesome. I love it.
Scales. So here's the real question, right? Does Vitalik or the foundation have an affirmative duty to run a bailout in this sort of circumstance? And the argument would be they bailed out a bunch of people in the DAO. They assumed a duty, and therefore they owe that duty to others in similar situations going forward. It would be very difficult to make this argument because you don't necessarily get to claim that there's an assumed duty based upon the structure of how Ethereum actually works. Even though everybody thinks/agrees that Vitalik and a few other folks at the Ethereum Foundation exercise an outlandish amount of control over the decision-making and the upgrade of the code, they are ostensibly a foundation. They do ostensibly provide code that has to be voted upon before it is updated. When they decided to fork Ethereum for the DAO, they did a poll. They waited to see that the vast majority of people, at least those who participated in the poll, actually wanted the upgrade, and they made the upgrade. And as we can tell, the majority of people supported it. Now, had there been a vast outcry of people saying, let's fork to fix parity, and the foundation said, yeah, we don't really care, maybe there would have been a little bit more to this in my view. But as long as you have the ability for the foundation to hide behind / use as a shield the concept of community consensus, and the fact that there was nobody who really was pushing hard for this, I don't know if you've got a winning claim there.
Well, you've got some.
Wait.
There's a lot of
Oh,
issues
sorry.
here too. You know, there's losses that might relate to the actual offering itself, right? That's where people are buying in. I think we said like 20 cents, and the statute of limitations on that is 3 years maximum. So you couldn't really bring any claims against anyone related to that. The SEC has a different timeline. And then there is claims that relate to secondary market trading. So we would, we'd take a look, for example, if I was going to look at a case like this, I would say, all right, the price spiked at, I think it was about 1,300 in January. Was that price pumped up as a result of false and misleading statements by Vitalik or people at the foundation? I think that is the type of case that you could bring now. One of the things that David raises is, this forking or lack of forking. And the question I would ask is whether we could say that that's some kind of scheme to defraud, some artifice to defraud. Drew was talking about, whether there was a duty that was assumed by the foundation, but would be under a state law claim. And when you bring a securities fraud class action,
Hold on a second, Bill. Hey, Tone, while we're having this amazing discussion, you've still got your screen share up.
Yeah, I know, because Drew has to run, and I wanted to get his last comments on this actual topic because we've gone off on a tangent on Ethereum. So that's why I have
Sorry,
it up.
Bill, I was trying to get you some airtime and some recognition there. Tone's
I don't need
production
my
value
face on
is
here
really
today,
bad.
man.
All right, Tone, you got me for another minute. What do you like?
Yeah, I just want your general thoughts on this SEC, Superstore,
Sure.
that I'm going after token law. What do you think it means going forward? And you did point out an interesting thing. clearly the SEC is saying that some of the 200 ICOs they were trading are securities, and we don't know what they are yet.
Right. So it could be that they had a bunch of Reg D and Reg S offerings and they were selling them without being an ATS or a securities exchange, which the Dow report said was a no-no. If it's that simple, then it's that simple. Or it could be, hey, look at those kids. Or it could be that there's, that they were selling some of these other assets that the SEC has a list and thinks to themselves, hey, here's a bunch of assets that we think are securities. If there is such a list out there, which there may or may not be, I would love to see it. There were a couple other things that were really interesting about that announced consent. The first thing that's really interesting is that there's a new remedy that's being provided here. And that is the SEC is hiring somebody to destroy the stock. That is to take all the tokens and destroy them. I would assume they're hiring some sort of vendor to burn the tokens. That's kind of interesting. I don't know if that's a standard type of damage or not, but that's something a little bit new. Another thing to consider is that there were a number of folks that were helping ICOs to place their tokens with others and were taking a percentage payment. That is the sort of activity that is traditionally done by broker-dealers and was being done in the ICO world by lots and lots of people who were not broker-dealers. So this may be sort of the kickoff to a wave of these sorts of enforcement actions. The last thing that I want to bring up is the fact that you've got a platform that had 200 some odd ICOs on it. You've got 6,100 people that are buying and selling on here. It could be that this is going to be viewed by the regulators as kind of a treasure trove, where they're going to be able to go in and find all kinds of information about all sorts of bad actors, whether it's ICO offerors that know that they're regulated by like securities, but are out there avoiding broker dealers, and so they could have some liability, whether it's people who are buying things that should be securities at 90% discounts and dumping them on these platforms at 70% discounts. That could be construed to be doing underwriting without a license. And one last point is you've got this entity that wasn't registered that's providing secondary exchange. It's interesting to find out whether they are considered to be underwriters, offerers, or syndicators.
Drew's getting interrupted by the 2-year-old.
Yeah, no, kids are absolutely adorable. Much better to look at than me on here. Everybody, it's a pleasure. Catch y'all later.
Thanks, Drew.
Bye, Drew.
Bye, Drew.
Yeah.
Another weird thing about that one too was how much the fine was compared to the ICO. Did you guys notice that? They got charged 200 grand, but they raised 3.6 million in the same story that crypto asset management one. It's like, that's just a tax, not a really punishment fine.
Right. Hey, David, like maybe another maybe another 2 years and you got an altcoin trader on your lap, man.
he really wants to get into this whole Bitcoin thing. All they know about is Daddy Bitcoin. They're all about, like with the CNBC, they love the melting Bitcoin in my hand. They only want to know where the melting Bitcoin's coming from.
Well, that's definitely your kid, David. It's not the milkman's son, that's for sure.
Absolutely. My daughter has blue eyes, though, so I question her all the time.
Hold on, wait a minute. I don't know how that could possibly be David's kid. He's far too handsome. It's far too handsome to have come from David. That's all I'm saying.
So look, I only got 1 minute left because I got to go take my wife out to dinner with people. So I'm just going to give my highlights from the last 2 days.
Please.
I think it's great what's happened. I think that, the SEC providing clarity. I think that the court in New York, basically saying ICOs are securities. I think
we're gonna get to that. We're gonna get to that. What is that? Was that fake news by Bloomberg or was that real news?
All the judge said was they're allowed to go to trial on the issue. It's not necessarily, and this goes back to what is the Hinman speech? Hinman gave an opinion, is it real? Is it not real? I think everything that's happening now is just good. We're discussing these issues. We've got 3-4 lawyers, talking about whether things are or not securities. I think these are all good things. The more information we get, the better off we are. And I think what happened in New York was, it's amazing how everyone believes that Bitcoin is one thing until they get arrested by a government entity, and then it's something else. And I'm actually going to be on stage next in a couple of weeks with some of the lawyers from Tezos, where we're debating some of the issues. And I think it's great that, defense lawyers in the space, they all say one thing when their clients say something else. And I think it's important of holding people accountable for what they say. And people have raised a lot of money in 2016 and 2017, and we have to hold those people accountable for what they told the public, not what their lawyers told them, not what the lawyers in retrospect are saying. Because one of my favorite things is take David Silver in 2015 from when he was on video and put me next to any defense lawyer from Perkins Coie, Cooley, Goodwin Proctor, or any major law firm. I haven't changed one of my opinions. They all have taken a 180-degree turn. So I do believe that this is good for the space. I believe the last couple of days, we still haven't seen a real fight from the SEC. This is enforcement by decree, but I think it's good. I think it's giving a little clarity, not much clarity, but a little clarity.
All right. Anybody want to jump in, or we're going to go back to the stories?
Well, I kind of don't think that the Zaslavskiy case gave us any clarity yet. It was just that a jury is going to decide the facts. If what was said in the indictment is true, then the jury has enough information that they could possibly find that it was securities. I believe they probably will. It would be a stretch for them not to, especially given the egregious facts that no tokens were ever actually sold. The jury's going to hate the defendants, but I don't think that we have that actually clear yet.
So Sasha, what you meant to say was, Sasha, what you meant to say was, I agree with what David just said.
You said that we have clarity from it, which I don't think that's the part.
No, I said a judge is going to let it go to. I said a judge is only going to let it go to a trial.
Yeah.
I said it's just good that we're starting to get clarity in the space. I think all of these things are just slow. They're just slow moving ways to get clarity. I agree with you. The judge absolutely did not rule what the headline suggests, but slowly.
Yeah, I mean, it was totally fake news at that point. It was very deceptive. It was clickbait. It was designed to get people to pay attention and want to surf it. All that was decided at that point in time is that if the facts in the indictment are true, the facts stated as to the instruments, which happen to be ICOs, suggested that those ICOs were securities. That's it. And that's a very narrow scope, and that doesn't mean all ICOs. So, it was very misleading.
Well, luckily though, it's a criminal trial, and that's going to move a lot faster than a civil trial. So we're going to have an answer on this probably fairly soon.
Right. So again, we're discussing this specific case out of New York. I know we jumped around the stories a little bit. This is the U.S. versus Zaslavskiy case involving the DOJ as well. And this was the case described in the New York Law Journal. I think it's like a 1-year anniversary of the Dow or something involving since the Dow. So I don't know if anybody wants to give a slight background on this case and what's going on here. Go for it.
I went through it pretty carefully. I could probably give a little synopsis. The defendant they issued Recoin, which is a real estate backed crypto. Then they did an ICO for that. It didn't say how much money they raised, but they did sell, I think it was 2,000 coins, but it didn't say the price of each coin. So anyway, then they merged that into this Diamond coin and said the same kind of statements about how Diamond is using real world assets to back crypto. And this is a lot safer. They made a lot of statements that were false and misleading to the investors about the safety of this. They said on their white paper it should go up 10 to 15%. They never used any of the proceeds to buy, the diamonds or the Recoin. They never actually issued any tokens. So it's very similar to the Central litigation. And, then their defense was horrible. They said, the lawyers said, well, we don't qualify as the Howey test because we weren't selling money, we were selling cryptocurrency. Well, that's been decided for a long time.
I hate it when guys do that. It completely destroys the arguments that I tried to make in 2014. It's just so bad.
Mm-hmm. And then the other one, that the Howey test was unconstitutionally vague. Those were their two defenses. And
how did anybody think that was going to succeed, Sasha? That
I know, right? It was like
the securities laws were unconstitutionally vague. Really?
And the judge made, the 74-year-old judge made a snark remark in his order, something about how the Howey test has been around for 70 years and it's been, influential in so many other cases that it's clearly not a vague, law. So I think
All right. Did you guys find anything else interesting in this coin New York Law Journal big article? I don't know if anyone read like the full details of it. This case is mentioned quite a bit in it. So is the Dow.
Honestly, I stopped reading law review articles like shortly after leaving law school. I just, unless I have to read it for a case or a motion, yeah.
Gotcha. All right. Any final thoughts on this news with the case in New York? Oh, if it's a jury trial in New York, is that something I can attend if I'm back in New York?
Listen, it'll never go to trial. This is going to plead out quick, and we're never going to get a trial on it.
Any final thoughts on this? If not, let's go.
It doesn't mean that lawyers are not going to be able to use this opinion. It's just, it doesn't carry a lot of weight. So it's out there. The analysis is the same analysis that other courts are going to be using, but there's a different type of persuasiveness depending on what type of an opinion it is. If it's an opinion at trial, if it's an opinion after evidence, if it's an opinion, in other contexts, it would have more weight. Summary judgment, for example, it would have more weight than a motion to dismiss. But I would use this one. It's not like David's default case.
Gotcha. All right, so let's jump back to this story. This is the one Bill left on. Do you guys see major ramifications? I mean, it was great that Bill pointed out this little fact about 200 tokens, some of which were securities. And this was a big judgment. So this sounds like anyone that took tokens as a form of payment could be in a little bit of trouble and considered an unlicensed broker dealer. I don't know, Bill, Jason, you guys haven't commented on this yet. Bill, why don't you go for it?
Yeah, I did a little bit of research into Token Lot, and it looks like the service that they were providing was, people would contribute either Ethereum or Bitcoin to Token Lot, and then Token Lot would use those proceeds to invest in ICOs, sort of like a middleman to make sure that people did it right and didn't, incorrectly create a wallet or something like that. So I think that it's fairly obvious. Well, I have to not say too much about this. I think one of the things that's really interesting about this case is, this is one of the real low-hanging fruit, I think, for the broker-dealer context. I mean, one of the things I've really been thinking about is what do we do with a Kraken or a Bittrex, these major entities that are trading venues that are not registered as broker dealers, not registered as ATS, not registered as exchanges. What's going to happen to them? If I'm in-house counsel for a US based quote unquote exchange, I would not be able to sleep at night because this is small potatoes compared to some of the very large venues that are transacting billions of dollars worth of what are likely securities. Or, one of the other interesting things about this too is, so let's say you're an exchange, right, and you're trading Bitcoin. Bitcoin is, at least now, legally considered to be a commodity. And then you have ICO tokens, which are a security. So you have the same entity that's trading commodities and securities. I don't know. I don't even know whether that's, legally kosher or not. So there's just so many cans of worms in the secondary trading market. And this is one permutation of that. And I think that I've said this before. I think that, everybody now knows that ICO'd products are securities offerings, and that's sort of, I don't want to say it's settled because we don't have any, case law on it yet or any official pronouncements on it yet, but we kind of it's an open secret. So what are we going to do now with these trading venues? And I think that's going to be one of the biggest regulatory issues in the coming year or two.
Yeah, no, I have another question on that regard. I don't know if this particular case sheds light on this or not. Like, I've always been skeptical of, the promoters in the space that receive payment in the token that they're promoting, right? Like, for example, Michael Turpin's, what's Michael Turpin's company? Transform PR, and Lisa Chang's Vambax. And there was, Watchman group is pretty popular. I don't know if they take it in tokens or not. But like the promoters, the marketers that are accepting payment in these tokens, like what happens in that realm?
Not good things.
Oh, I don't know. I mean, there's an argument that could be made that the use of the tokens as payment for receiving these things was nothing more than expression of the use of currency, or the token has multiple uses, including the use of currency. I mean, I'm not willing to exclude that argument and take just a one-sided approach to the way that tokens are used. However, if you could scroll back up for a second, Tone. What I want to focus on in this report here is right after it says more than 200 different digital tokens, says which the SEC found included securities. Now, we all know that there was no announcement by the SEC of what those are. So, but this is what you get in an administrative arena when an enforcement action or an administrative action comes up against you, is that the SEC can summarily decide on its own if something is an investment or a security or not, and based on its own findings, then take action. And that's kind of the dangerous thing here, is that, we didn't have an adjudication of that issue. We don't know what those were. We don't know what the elements of those were. So if I'm trying to advise maybe an OTC broker of what assets to engage in or not, I'm now not able to adequately advise my client because I don't know which one of these 200 different digital tokens the SEC has already summarily decided are securities. Now, I'm not a dumbass. I know what the qualities are. I know how to properly advise a client, but say it's an attorney other than me and they're trying their best to advise an OTC broker or something along those lines, they're without that information. So that's the point of this story that really stood out to me, is we have some, as I think it was, who said that they'd really want to have that list? Was that you, Bill? Or no, it was Drew. It was Drew. Yeah.
Yeah. Hey,
Drew's
Jason,
right.
let me ask you this. Is this something that, like, you guys as security lawyers advising clients, is this something you can demand from the SEC under like the Freedom of Information Act?
So most likely, what you've got here is depending on the stance of the case, and I don't know the stance of the case. I'm not familiar with it enough. It's only been a couple of days. It says that the SEC charges ICO Superstore. So what does that mean? We're outside of the administrative realm, right? And we're getting into the public domain. So depending upon whether or not this is going to be defended or not, or if it's just been an agreed upon thing, there's certain elements that may or may not be subject to public review, including the confidential records of the SEC in their investigation, which are not subject to release during their investigative period. So I don't know enough to be able to say whether or not I could acquire copies of these or not. You know, that's, yeah.
I think they each got, like, the founders got fines, like the token lot founders, for 45,000 each, and they were barred from ever being on the penny stock.
Yeah.
Bar.
So
they just settled. It was like,
so we're never going to know.
No punishment here. Yeah, we're never going to know. They just said, okay, fine, we'll pay the little tax here and, you know, keep on going.
Yeah.
Not going in this direction, but, you know.
So all that is a consent order then, right? So even the headline here from the SEC is misleading. They didn't charge them with anything. There's a consent order in there, and the matter's done. So.
All right. So clearly, you know, I guess not even a bite then. This is just, you know, still barking by the SEC.
Well, I mean, I think ICO Superstore would say that they got bit.
Right, but right, but I mean, like,
I see Bill in the background kind of laughing and agreeing.
Yeah,
what's so crazy? How can they say we're here trying to protect investors? Okay, we're worried about these investors' money. Let's burn the tokens. Why wouldn't and charge these people 200 grand when they raised 3.6 million worth of people's money? Like, why wouldn't they give that money back? I don't understand the burning of it, or why the fines are so small if they really want to discourage this kind of activity.
Well, I think if we read into it, it was my interpretation that the tokens that Token Lot had received were the ones that were supposed to be burned. But maybe I didn't read that right.
And there's no indication that there was fraud.
I see. So the tokens being burned are what they were paid in, like, a commission for their services.
Yeah, I'd need to read it a whole heck of a lot closer.
Okay. That makes way more sense.
I started looking at this about, 10 minutes before the show started because Tone.
Yeah, that was my bad on that one. All right. Yeah, this story kind of came up out of nowhere. I wasn't really, I was on a cruise, wasn't paying attention to all the legal stories. Look, but Token Lot was going to end up exit scamming anyway, like everybody else does. As far as I'm concerned, the SEC did him a favor and let him exit with a $40,000 fine. All right, guys. We got a final story. I think Manny brought this up, even though we're going to make this really quick. I know Manny's not on the show today, and it simply has to do with, the payment to exchanges to list coins. We're not going to go through the details of it. There's also a Medium article that you guys are welcome to check out, the viewers. All of these links are in the video description. Very detailed story of all behind the scenes bullshit that takes place of, like, listing coins and general articles of listing coins. And then, I got to switch my screen share 1 second. Let me share main screen and let me jump on this. So somebody got this graph together, and I don't know how accurate it is. These numbers seem a little unreasonable. It just goes through every single exchange and how much they charge in order to list their coin. And it ranges from like 20 Bitcoin to, hundreds of thousands of dollars in order to list your coin. Now, we're not going to talk about any specific exchanges, and I'm not sure if this list is accurate or not. But just in general, what do you think of this practice? I know that in the traditional markets, there is a fee to be listed on a New York Stock Exchange or a NASDAQ, but that is, a legal standardized fee. What do you guys think of this? We don't need no regulation market. You pay us enough money and we list your coin. Libertarian way of running capitalism. Like, what are your general thoughts?
That's what the SEC would call pay to play. That's what that is, right?
And what have you like? And historically, how have you seen these initiatives end?
Well, I can say, that let's say if we're talking about the New York Stock Exchange or we're talking about NASDAQ, right? the exchange would have to submit its proposed rules to the SEC. The SEC would have to approve those rules. There would have to be standardized practices. You're going to have a tremendous amount of disclosure by the company to the exchange. So there's a set formula of requirements, and it's not just payment, that a listing entity needs to satisfy to be listed somewhere on a securities exchange, right? And you know, this just goes back to what I was saying earlier, that this procedure that we have, and I see a couple of these that are US based, the procedures that are required of exchanges and what are and what's happening in the crypto space are pretty widely divergent. And we're going to, again, you know, I think we're going to see some enforcement actions of these exchanges that come within the U.S. jurisdiction of the SEC, because it's way outside what would need to occur if this, you know, if we're assuming that these are securities, that these ICO'd products are securities, then, you know, they need to have a suite of procedures that they don't have. And I think, you know, one of the things that we're seeing in the crypto space is people saying, well, I'm not, look at my offering white paper. It says that I'm not a security, so I'm not a security, so I don't have to comply with the laws. I think that you know, you can't avoid the application of the law by violating the law. And that seems to be the legal limbo that we're in. And again, excuse me for the verbal diarrhea, but it's the cough medicine is messing up.
All right, Bill, you're just having Tezos PTSD. That's I think something that we should, you know, from a fairness standpoint is as we're looking at this list here on the screen and it's showing the cost of getting on here, what we don't know and we don't have evidence of is the other procedures and requirements that these exchanges require tokens or coins to comply with in order to be listed. I know that I've been doing quite a bit of work in analyzing coins in preparation for, you know, letter analysis for listing. It's something that I've been doing lately, and I take that work seriously, right down into, you know, going into the software, looking in the code, looking at the realities of the scenarios in order to give my best independent assessment of whether or not a token or a coin is a security or not. And then that letter would be used to, you know, present as evidence to the requesting exchange as some form of proof of whether or not they're a security or not. So I do know, without naming any names, that there are exchanges on this list that do require that process. I won't comment on who they are or how much they charge, but you know, so we don't have all the facts. Although, you know, when we're looking at some of these prices, wow, that's more than the NASDAQ charges. Bill? What's NASDAQ? 50 grand?
Like, yeah, it's like 25 to 50 grand.
Yeah.
Oh, Bill, you're muted.
It's based on the market cap, essentially, of the entity. There's tiers.
Yeah, but there's a cap on it, isn't there?
I'll Google it. I thought it was like New York Stock Exchange was like 25 grand.
Yeah, sorry, we may be going down a rabbit hole we don't need to go down on. The only point that I wanted to make is that this is not and this does not include all the requirements for the exchanges that are listed on here. Although this is a very damning list, you know.
One of the things I really liked in that Medium post, the Nick Carter one, the Underbelly, was discussing the wash trading and how these exchanges are trying to make themselves look a lot more liquid, like they can provide more liquidity than they probably really can. I thought, I never thought about that side of it, so it was educational to read.
Well, and that's a whole nother thing. I mean, when you get into the definition of an exchange as something that is trading securities, there's, and I've said this many times, there's all these rules that you have to comply with, with respect to collecting data about trades and sharing it with other exchanges, so the market knows whether the prices are the best prices available. You have to, so if I'm on Binance, for example, and there's a better price on Kraken, me as the exchange, I have to execute at the better price that's on Kraken, or reroute the trade somewhere. I have to disclose my payment for order flow, whether I have bots, essentially high frequency traders that are operating in my market ecosystem that are getting special order types and preferences, whether they're paying to jump to the head of the order queue. And
pay to play. That's your flash trading, right? That's pay to play.
And it's your flash trading. And I think all of this is endemic to these crypto trading venues. And it's really buyer beware, because, you may be thinking that you're getting some deal with some sort of a trade that you're paying no fees or no commissions, but you're getting taken advantage of in the metrics of how the trades are structured themselves. So it's a black box that really needs to be sorted out. And what I've experienced is that people are coming from Wall Street to exchanges and really displacing, traditional crypto programmers, and they're building exchanges that comply with all of these regulatory requirements in the assumption that, that's what's going to be coming down the pipeline for all of the exchanges.
All right, guys, thanks for that commentary. We're gonna go ahead and wrap this up. I just have three very short, announcements. They weren't stories big enough to lead to a discussion. So I'm just gonna announce them. If you wanna throw, a quick sentence in there on your thoughts, feel free.
Tone, stop screen sharing.
No. No. Well, so the CBOE is looking to launch an Ethereum futures contract. Again, I don't think this is worthy yet of discussion.
It's not a contract. It's a platform, isn't it?
No. This is the CBOE futures contract.
Sorry. Yeah.
The way they did it on Bitcoin. So they want to do it on Ethereum. Hopefully Ethereum implodes before this happens, because that would be unfortunate. Maybe we'll talk about it as a topic next week if you guys want to. Also, I don't know.
Thing on that, Tone.
Go ahead.
I think it was in that article, they said the success that the Bitcoin futures have been having, like it's exceeded 24,000 trades. It's up 58%. So that I didn't know that it was doing that well, or that people were that interested in the futures of it. So, and then on a conspiracy theory kind of side, I was wondering, could they have played a part in Mr. Hinman's decision to declare Ethereum not a security for the purposes of getting this going, because there's a lot of money to be made if there's transactions happening.
I almost have to assume that they did, even though that would probably be irresponsible on the part of their lawyers. That would be my general opinion.
Mm-hmm.
So let's keep an eye on this, and the next time this is in the news again, now that Ethereum has fallen like 90% in value, maybe they're not as interested anymore. So we will keep an eye on this, and we will probably bring it to you. This is more of a financial story.
What is Ethereum at today?
Like $180 or something.
It's still under 200?
I believe so. Let me check right now on my app. I don't think it's. I don't like putting up Ethereum up in screen share, but I'll check it for you right now.
You really are an Ethereum hater, aren't you?
I am. I always was. So it's at 180 right now, but it did hit 166 earlier today or yesterday.
So on that note, and I think that I felt strongly back in the day, and we talked about this a little bit, that Ethereum's advertisement of immutability was pretty much made laughable after the DAO fork, right?
Of course.
So I just saw a tweet by Barry Silbert talking about how Ethereum Classic's developer core has gone from 11 to 38 in the last year, and it's completely decentralized. And it looks like the original Ethereum is moving forward, and I've seen quite a bit of activity on it lately, including more volume than what Ethereum actually has. So interesting development in the Ethereum versus Ethereum Classic pre-DAO fork world, and in Ethereum moving up in the world. Ethereum Classic, if you will.
We'll see. All right,
my dinner date, Lynn, is here. We'll
Hi,
just say
guys.
hi and we're signing off.
Hello. All right, Sasha, before I sign you off, for you,
Bye.
Before
Alright.
he signs you off, he has something to say.
Oh,
or you're gonna, one very quick thing. What are your thoughts on the SEC chairman wants to let Main Street investors in on private deals?
Oh yeah, I kind of like this, and also like they were saying, instead of making the financial reports be quarterly, have them every 6 months. I feel like that would, a lot of people, it causes the companies to do maybe some drastic actions to keep their earnings always really strong every quarter. So if they didn't have that kind of pressure, maybe they could have more long-term success. And then also for the everyday investor being able to access more of these things, I think that's always a good thing.
Well, I'm sorry, did you say 6 months or 6 weeks?
6 months, like instead of every quarter, having them every second quarter, have them put earnings.
Gotcha. All right, cool. Yes, so we'll see. We'll keep an eye on this as well. Maybe this is worthy of a full story. All right, Sasha, we are going to enjoy your dinner, and we'll see you on the next episode.
All right,
Bill.
thanks guys. Have a good night. Bye.
Bill, I got to tell you, you don't look good, man.
No, you
Go
don't.
get some sleep.
And
You're
you
muted
Bill.
too. Yeah.
I'm gonna unmute you. Nope.
Yeah, so thank you again, everybody, for listening and watching. I enjoy this as always. This is really becoming one of my favorite things to do every week, even though it sucked today because I just wanted to close my eyes. But I'm going to sign off. Everybody have a great week, and we'll talk hopefully next week.
All right, cool. Let you go, Bill. And Jason, if you got a minute to comment on what you think about the SEC letting in more retail investors on private deals.
First of all, Tone, what I want to say is, as usual, as with any party, I'm the first to arrive and the last to leave.
Yeah.
And here we are once again, you and me. I also thank my Great Dane, Beatrice. I'm pretty sure I just heard her take the box of cookies off the kitchen counter and eat them all. And now this is self-imposed guilt. Of what this is. Anyway, I think the idea of opening up investment to Main Street investors has been it's kind of waxed and waned if we look through history, right? When it comes to the SEC's mission, which is to protect investors by making sure that they're getting the adequate disclosures that they need and that they can make those decisions for themselves. It's a double-edged sword, right? Because you have businesses and we have a booming economy, and there's people with great ideas and they want to raise funds. So I think in allowing new businesses to be able to raise capital in a crowdfunding type manner, the masses or the people that are in their neighborhood to be able to invest in it, I think that there's nothing wrong, and I encourage Main Street investors investing in Main Street businesses, and that's different than investing in crypto businesses, right? I think that's kind of what I'm trying to get at, is that when Main Street invests in Main Street, then the community will use those services, the community will support those services, those businesses, and those businesses have a much higher likelihood of succeeding if those businesses are in the business of being in business. Right, we've talked about that multiple times, either on my own show or on Crypto Scam about Ethereum. And we talk about, businesses that are in the business of taking people's money or business that's in the business to do business. And there's a distinct difference between the two. So I absolutely encourage the process of opening up investment to Main Street investors if it's for the right reasons. But unfortunately, what'll probably end up happening is somebody's going to get taken advantage of, and then somebody's going to say, hell, this was a terrible idea. And, yeah, but I don't mean to end on a downer. I don't want to end on a downer.
Yeah. All right. So then I'll just make one last announcement. There's really not much to talk about. The lead plaintiff, the lead general counsel for the company Ripple, for years, runs the Ripple token scam, has resigned. It probably doesn't mean anything. He probably found a better job, didn't want to deal with Ripple anymore. So just an announcement. They have hired other lawyers like Mary Jo White, the former head of the SEC, to defend them in those lawsuits that Ripple is a security. This is just news event. Unless Jason has some insider information as to why that person quit. I believe it was a she, though I'm not sure.
Two things. One, I don't know who the lawyer was. Brynel Lear. Brynel Lear.
Lear, yeah.
Yeah, Brinley. Yeah, I don't know Brinley. Never met Brinley. I don't even know what Brinley did at Ripple. What I can say is that I've been counsel for a couple of different companies before, as you know, Tone. Mm-hmm. And there are times that I've had to move on to other projects. We can go all conspiracy on this if you want, right? But you have to understand that a counsel's job when they leave is to maintain confidence and not give away privileged information, which means that no longer representing somebody, the reasons for that is also privileged information. And there are two different ways that you can leave an organization. You can do it quietly, or you can do it in a way that we call a noisy exit, right? And a noisy exit is basically happens when there's public announcements, waving of arms in the air and saying, fine, I quit. I'm no longer with you. I'm not associated with you. I don't want anything to do with you. I'm no longer your attorney. Have a nice day, right? And usually when I'm a lawyer and I see a noisy exit, that means that there was some request to do something that the lawyer felt was either repugnant or was unethical or could no longer engage in because there was potential criminal activity going on. Whether or not Brinley is doing a noisy exit here, or it's just an oversensitive news media cycle that's paying attention to everything that's going on with Ripple, I don't know. But we could have fun speculating about it.
Yeah, no, again, I'm gonna give them the benefit of the doubt that Brinley had a job and she decided to move on to a better job, and that's about it. But again, if anyone hears something about it being a noisy exit, that is certainly something we would like to maybe cover in a future story. Well,
Brinley's obviously got talent, right? She handled class action litigation for PayPal and eBay, right? You don't handle class action litigation for those large firms without having talent, right?
Yeah, I'm curious if Brinley saw my episode of Crypto Scam Ripple a year and a half ago. So that's my number one question. So Brinley.
Well, Brinley, if you're listening, we'd like to know two things. One, do you watch the show? Are you a fan of Tone? And two, and you don't have to answer this, but was this a noisy exit? We'd kind of like to know. So.
All right, cool. So on that note, hey, Jason, thanks for being first and the last for this show.
Hey, life of the party, you and me.
Thanks so much.
We've done this a lot, man.
I know. So thank you so much, guys, for hanging in there with us. I know everyone is dying for the price of Bitcoin. I don't normally do it on this show, but I figured the show lasted long enough. Jason, feel free to go. And Oh, I can't hear you anymore. I don't know why. Oh, because you're muted. Feel free to get going. 2 minutes on price, and I'll let you guys, for those that hung in there this whole time, this will go very quickly. Look, I've been live forever. My Twitter is 30 notifications that mention my name. God, I can't even keep up with all of them. That looks like one of my videos about silver. Let's just glance at the price of Bitcoin. I didn't do price analysis today. I'll try and do one tomorrow morning, but I got to go to Madrid tomorrow. I'm currently still in Barcelona. Bitcoin is trending up a little bit. That's the weekly chart. That's the daily chart. Let's go to the short-term charts. I drew this red line. I drew this red line on a 12-hour chart about a day and a half ago. That's because this candle was a red 2 trading below a red 1. It is no longer doing that. My stop loss is the blue line, which is fairly reasonable. I still think there is a higher probability that we will go down before breaking this blue line, but this is why you set stop losses. I mean, anytime you have price flips, you should not be in the market. You can either go back to cash or remain with your short trade until your stop loss gets hit. That is a decision for each trader. I see that the shorts continuing to go back up and they're continuing to rise. In general, that creates an environment to go short. There was a red 2 trading below a red 1 on a 4-hour chart that almost made it to a 9. It has now price flipped. You're still under your stop loss, but you now have a green 1, a green 2, and you might get a green 3 above a green 2. So again, it's trader's preference, whether you want to flip your position to cash or even flip your position to a bullish trade next candle if it starts trading above the current candle. Again, this is trading. The amount of shorts versus longs is historically high. Huge number of shorts, not enough longs. And normally this is not when prices go down. But then again, nothing is perfect in trading. Long-term chart to me looks like it's ready to drop. The Ethereum chart is having a little bit of a bounce, but now we're away from Bitcoin. So there you go. There's the price analysis, guys. And now on this note, I will come back to screen share and I will shill my affiliate code. So if you guys like this show and other shows like it, please support via affiliate codes. They do not cost you anything extra. So that's one way to support the show. And of course, feel free to do your Amazon shopping as well by first clicking any one of these links of my tech gadgets or Saifedean's book, which is a must read, and then do your Amazon shopping. And that also helps support all this free content. All right, now I will get off screen share. It's 12:30 in Barcelona. Either I gotta go to bed or I gotta go find a place to go out. I have 5 minutes to make that decision. All right, guys, and some of you may find out in the morning based on whether there is or isn't trading Bitcoin because I gotta get to Madrid. All right, guys, thank you so much for watching, and I will see you all next week on another Bitcoin Law Review.